So what I'm going to do to start is to welcome Lena Helinska, who is member of the UNA Europa Self-Steering Committee in Sustainability and the UNA Europa Task Force for Sustainability and Climate Protection. She's working towards a doctorate through an interdisciplinary programme, focusing on the role of science in public international law. Our interests include, but are not limited to, defining and implementing sustainability and its indicators, progressive interpretation of law, economic analysis and risk assessment. Lena participates in a number of research and international projects, among which the creation of the UNA Europa joint Bachelor and Sustainability is particularly important. You might have heard us just talking very briefly about that. And we've got the very good news that accreditation phase 1 has been passed with flying colours. So we're hopefully on our way to having students starting on the programme in September, maybe. That's the wish. She was recently she's also coordinated l'école de droit français and the Master's 2 Mention droit privé programme, which I think is private law, if my translation is correct, thank goodness. It's been implemented at Jagiellonian University in Kraków in cooperation with Université d'Orléans. Lena is currently at the Centre for Advanced Sustainability Studies, and she'll present today on testing the water, the interactions between law and science in international disputes concerning watercourses. Over to you, Lena.
Thank you so much. I will do my best to be brief. Please excuse me if I will stumble every now and then because I'm a little bit under the weather. I have my emotional support coffee with me. So perhaps everything is going to be fine. And now I would like to just ask you for confirmation if you can see the slides.
Yes.
Okay, wonderful. So I am very aware that the topic, testing the water, the interactions between law and science in international disputes concerning watercourses, is a broad one, because if we want to look at international disputes in general, you will see that we have a lot of courts, tribunals, but also a lot of arbitration proceedings, which all are based on different rules. You have different parties to the disputes. Some of them are resolved very quickly. Some of them take a lot of time. So what I'm going to do here is I will try to show you why I think this is a very interesting subject matter, why I think that there are plenty of issues that are worth discussing, and I will try to show some examples, those which I think are quite representative due to the gravity of the situation and to the status of the court which was dealing with those cases. Obviously, I know that most of you, or rather, maybe I don't know, I presume that most of you are not international lawyers, so I will try not to dive too deeply into the nitty-gritty details of procedures and other fairly boring lawyer stuff, but rather I will try to show where exactly those problems, or rather challenges, appear when it comes to interactions between law and science. What is the source of the problem? If we had to generalize, I would say that there are 3 fairly common scenarios where there is a dispute between international, between states in an international setting. The first is the case of the tragedy of the commons, where the states share a watercourse and there's some sort of usage of this watercourse which diminishes the possibility of use of the same watercourse by a different state. For example, if you have a shared river and you decide to use it very heavily for navigational purposes, have a lot of vessels on this river, then the state which is located on the other border might have difficulties with navigation from their side. As a lot of other resource-related questions are typical for the tragedy of the commons as well, overfishing, and for example, extraction of some materials, some minerals from the riverbed. There are plenty of situations in which such problem may appear. Secondly, the alterations of the water course related to dam building, to erosion of riverbanks, and it's not always intentional. It's often a result of some construction activities. I would say it's an externality of many investments that are being done on riverbanks. But this is also something that might be problematic, given that, of course, it changes how this shared river functions, but it also can result in transportation of sediments, of a change in the river flow, etc. A lot of things that might influence not only your neighbor from the other side of the river, but also a downstream state, which I will mention in a second. And the third thing is transboundary harm. This is what we usually think and what we extensively deal with in international law. These are the situations in which the actions of one state have consequences on the territory of another. You might have heard about the ongoing debate on state responsibility for climate change. This is an example of such a situation in which we could try to see some causality between actions of one state and consequences on the territory of another. But there are also some simpler examples, such as pollution or, for example, extinction of species related to the fact that an upstream state decided to modify the ecosystem. And the situation of downstream states, so those which are located in the lower part of the river, the one that either joins into another river or falls into the sea or another body of water, is usually considerably worse than that of upstream states. So those states which on the territory of which the river is located from its source to a certain point. Because obviously, if the upstream state is going to either pollute the river or restrict its flow or do anything else to the river, then the situation is likely to affect the downstream states considerably. And what also makes it quite important is that we observe increased water scarcity for various reasons, for climate-related reasons as well, which is paired with a growing demand. This growing demand not only for agriculture, but also for various production-related purposes is going to grow also as our developing states will try to catch up, will try to do more to boost the economies. And why is the law and science interface so important from my point of view? I would say that the analysis of causal links, risks, and consequences, which is quite important for many disciplines of science, is really indispensable for law, both for determination of wrongdoing, so if somebody breached the law or not, and to what extent, but also for delivery of just judgments, because the judges often dispose of often use something which is called the margin of discretion. This is a situation in which you have an open-ended norm and you can interpret it in various ways to deliver a fair and equitable, hopefully, judgment. And in such situations where you have those open-ended norms or standards or clauses, then it's very important that the judges understand what the nature of the problem is, what are the facts, and what are the risks or the possible consequences of a given judgment. In the case of water courses, this is particularly difficult. There are multiple functions of water courses and multiple related interests at play due to the huge environmental, but also social and economic significance. for example, rivers, which we mentioned a little earlier, are very often extremely important for local communities, not only for biodiversity and other environmental aspects. We'll see that also later on. And this high complexity of water ecosystems, which is also linked to the possibility of long-term effects and the fragility of the balance that is often required for the water species to thrive. This is something that is quite difficult to grasp when you are a non-specialist. And this is also something which is quite difficult from the perspective of law, because the moment in which this harm may appear, for example, in the form of a disruption of a food chain, which will lead to extinction of species, this can be a really late moment in time, as opposed to the moment at which the case is being discussed. And Pantarei, everything flows. The flow of water makes it more difficult to pinpoint the source of harm, to trace evidence, and to actually, point fingers at those who are the wrongdoers. So I would say that the water courses are perhaps the hardest out of all typical or fairly typical cases. The water courses might be the hardest case that the international courts and tribunals are dealing with, but they are also fairly likely to happen. Why is it so important for international law? Why I decided to talk about international law and not any other sort of law? In general, international courts and tribunals usually operate on the basis of broad and general guidelines, which do not provide much guidance in scientifically complex disputes. It means that the judges have to put in considerable imagination and goodwill to interpret their guidelines in such a way that it benefits science and it's scientifically sound. Obviously, that's very hard. I'm not saying that they are not doing it out of spite or anything, but this is something that we must be aware of, that in many cases, the law, their own law that they have to adhere to, is not particularly precise when it comes to science. Secondly, international environmental law is a fairly new branch of law. The wider discussion started in the 70s, and the World Court is first the Permanent Court of International Justice, now the International Court of Justice, its successor. They are a product of world wars, so they are earlier than the international environmental discourse, and it has a considerable impact on the fact that they are not very well equipped to deal with it. And the International Court of Justice, I'm mentioning only this court at the moment, was chosen by me as an example because it has a considerable impact on the international law, even though there are no binding precedents in the sense that the previous rulings of the International Court of Justice are not necessarily binding in other cases, and it interprets law, it applies law, but it does not necessarily create law as such. This is not that important. I just wanted to mention that. And I would say that the most important thing out of all is that in international law, a lot relies on the willpower of states. If the states are afraid to submit certain scientific disputes to a court because they don't know how it will be treated, that they will avoid trying to use the international dispute resolution system. And they might be unlikely, or they might be quite resistant to attempts at enforcement of scientifically involved judgments. For that reason, it's quite important to ensure, for the peace of mind, that the scientifically complex disputes will be analyzed in a coherent manner, which will guarantee a sufficient level of legal certainty. So their ability to sort of presume how the dispute might turn out, how the discussions may look. And why is that important? It's important also because it's very hard to change international law just like that. The process of designing and accepting various new norms is complex, politically very long, and also when it comes to the level of detail that is usually involved in in international legal regulations, it's obviously not huge. They are rather general in scope, due to the fact that they have to apply to a wide range of circumstances. So they are perhaps not the best tool to address some new urgent scientific issues that emerge. And I would say that injecting science into international dispute resolution is difficult for a number of reasons. First of all, there are some procedural measures such as site visits and court-appointed experts, which are very rarely used because of how expensive they are and how complicated they are, and a lot of other doubts that international judges and arbitrators have towards those measures. Secondly, attempts consultations conducted by the judges are not always considered transparent, in the sense that sometimes they are trying to consult experts outside of the courtroom. There's a whole phenomenon called shadow experts, expert fantôme, or rather ghost experts in a more direct translation. So people who are being consulted outside of the procedure just because the judge thinks they need to check something. Obviously, it's good that they try to understand, but on the other hand, it's easy to understand the concerns of the parties which are not participating in this dialogue. With no obligation to adhere to previous judicial practice, it's quite obvious that the practice can shift in time. So this element of legal certainty that we talked about is not yet present, in my opinion, in scientifically complex disputes. And also, when you look at lawyers, they usually have a very surface level understanding of scientific issues. It's not a flaw. It's good that they are experts in their own field, but there are at the same time a lot of attempts to create some very, I would say, scientifically literate judges. And while I think that it's scientific literacy of judges should be as high as possible, I find it highly unlikely to create a group of judges who would be experts in absolutely everything. Also, because if you look at the complexity of the disputes, they would have to be experts in really a huge number of disciplines, and even people who are not lawyers rarely possess such knowledge of 5 or 6 or 7 very complex disciplines. And the last solution, which is often proposed as some sort of a magic bullet, is specialization. So they say, okay, if it's hard to deal with environmental cases, perhaps we should have an environmental court, an international environmental court specifically for such proceedings. And there are 2 problems with that. First of all, it's not always easy to delineate what is environmental or what is non-environmental there are elements of many problems which are very strongly intertwined in a plethora of international disputes. But also, those attempts have been made. For example, in the International Court of Justice, there was a chamber for environmental disputes, and it was actually resolved after 17 years, during which the chamber has not received even one case. So, of course, there were environmental cases, but due to the fact that the court as such had higher legitimacy and the cases were complex, this specialization didn't help much, or it's a very huge understatement. It didn't help at all in this case. An important disclaimer, I'm not saying that specialization is always wrong. There are some highly specialized, more narrow sub-branches of international law, such as international trade law, where there are specialized courts or rather dispute resolution systems, and I would say that it functions much better in those areas. But as a general rule, I wouldn't say that specialization is the solution for scientific disputes. And now I wanted to show you some examples from the International Court of Justice. The first case is the Gabčíkovo-Nagymáros project, which was a dispute between Hungary and Slovakia. I'm sorry, there was a machine whirring in the distance, so I just turned off my mic for a second. But yeah, the first case is the Gabčíkovo-Nagymáros project. It was a dispute between Hungary and Slovakia over a dam project. In general, Hungary withdrew from the project and Slovakia decided to continue. And Hungary raised a number of environmental concerns. Hungary was worried about lower water levels downstream, which would negatively affect groundwater recharge as well as wetlands. The reduced risk of seasonal flooding, which was for some a very good consequence of dam construction, was from the Hungarian viewpoint a bad thing due to the fact that it would significantly alter the ecosystems downstream. Obviously, due to the fact that the fish cannot migrate through the dam, it could have an impact on fish populations and those species which depend on natural flow variations, because what the dam would do would also be to regulate, obviously, the flow of the river in such a way that it would not be subject to those seasonal natural variations over time. Sediment trapping, changes in the erosion and deposition patterns were also a concern, as well as those new hydrodynamic conditions, which potentially could lead to riverbed degradations and issues with navigation. It's quite straightforward, even for a non-expert, that in a situation where the flow is first restricted and then quickly increased when the water is being dumped from the dam, it can affect the riverbed to a greater extent than the river in its natural state. Also, what was mentioned was that the higher temperature of stagnant water might relate to algal blooms and decreased oxygen levels, further harming the biodiversity of the ecosystem. Here, an important mention: the algal blooms were a concern in two cases in which the concept of rights of nature was discussed. In one of those, the rights of nature were applied or were adopted, and it was the case of the Mar Menor lagoon in Spain. And in Poland now it's being discussed in the context of the Oder River, which was also very heavily affected by algal blooms. It was a huge environmental disaster. A lot of fish died, a lot of other critters died. So it was not a nice view. I'm mentioning that because earlier there was a lecture on the rights of nature by Professor Schweda, and this is something that ties to those previous conversations. Those algal blooms, which might seem very harmless at the beginning, now show some huge consequences that might have been a little bit underestimated in 1997 when the judgment was delivered. And the last thing was the potential for pollutant accumulation. It was also mentioned as one of the auxiliary arguments. What happened next was that Hungary tried to invoke three major legal tools or tricks to argue that their withdrawal was lawful. The state of necessity, so they had to prevent environmental degradation, according to them. A fundamental change of circumstances, which was based on the fact that they apparently weren't aware of the environmental implications of the project later on, early on, and impossibility of performance, that they would be unable to go through with the project in a way which would be safe and adequate, etc. But the court rejected those arguments. They said that there was no grave or immediate danger, and Hungary failed to prove that the only option to secure the well-being of the ecosystem was withdrawal from the treaty they had with Slovakia. Secondly, they said that the changes in ecological awareness and political conditions were not entirely unforeseen. And first of all, the core purpose of the treaty, which was construction of the dam, remained intact. And they also said that construction could technically still proceed, and even if they wanted to change something in this treaty, they could modify it, they could renegotiate its conditions. So it would be hard to say that there was an impossibility to perform. On the top of that, they said that Slovakia also breached the law because they decided to divert the shared water course into their own canal. And this is a non-scientific issue, but I wanted to mention that so that you know how the dispute ended. When it comes to the environmental aspects, the court was quite vague. The court recognized the evolving importance of environmental concerns. They underlined the need for further scientific monitoring and cooperation. Further on, not in this case, but some years later, it evolved into the requirement to conduct a thing which is called environmental impact assessment. What was also curious was that the principle of sustainable development was somehow recognized. Maybe not as a principle of international law, but something that is that has to be taken into account. And the changes in scientific knowledge were acknowledged as something that happens and something that has to be taken into account. Now we are talking about something which is called the precautionary principle, which means that if there is scientific uncertainty and a certain level of risk, we should err on the side of caution. This acknowledgement was also in some way foreshadowing this precautionary principle discussion. But in general, the court did not engage with scientific arguments. It instead hinted to scientific uncertainty. There were, in general, some divergent views on the evidentiary threshold and the required precaution, especially while the judges, some of the judges thought that it's good to err on the side of caution. They pointed out that it would be a little bit too premature to say that scientific certainty would be enough. Because in case of some substantiated or speculative arguments, creating a false sense of uncertainty could be an option. And one thing that was quite interesting and was not addressed in a way that would make me say that the issue was resolved is the issue of the harm being immediate, in the sense that if you have some long-term effects, for example, long-term health impacts or long-term biodiversity impacts, it's very difficult to show that the harm is going to happen immediately. The other case was pulp mills on the river Uruguay. It concerned the construction of 2 pulp mills on the shared river. Argentina claimed that Uruguay did not fulfill the procedural and substantive obligations under the statute. A lot of those concerns were related to consultation and some other procedural aspects that we will not explore today more deeply, but I just wanted to mention the scientific components of the case. In general, Argentina was worried about air and water pollution, which would threaten biodiversity, fisheries, tourism, and to some extent local communities as well. And Uruguay said that they used the best available technology, which was, according to them, the elemental chlorine-free bleaching, which would, according to them, was able to significantly reduce any sort of risks related to water pollution. And what happened was that both sides presented a range of technical studies on water chemistry, effluent characteristics, and ecological effects. It was a lot. The court was quite frightened when they saw the body of evidence which was being submitted. But even though there were a lot of studies, neither of the sides escaped concerns over the adequacy and objectivity of the data they provided. One of the problems was that the issue became so highly politicized that any, I would say, objectivity and impartiality of the experts was feared to be tainted by this political nature of the dispute. What happened next was that, according to the court, those claims of pollution and general harm to the Uruguay River were not proved by Argentina. But what was quite interesting is that the environmental impact assessment we mentioned earlier was for the first time considered an obligation of states. This was a very vague obligation, at least in the way that the court framed it, but it meant at least that the states are obliged under general international law, so all states, to conduct something which is called environmental impact assessment, which is to say that each investment should be conducted only after a very careful analysis of possible risks and consequences of construction. Obviously, you can see that I don't provide a precise definition. This is because precise definition does not exist in international law, even in some international legal tools which deal more precisely with environmental impact assessments. But what is quite important is that the scientists are not entirely in agreement as to what the environmental impact assessment should include, what should be the depth of the assessment, what should be the scope of it, whether, for example, indigenous knowledge and consultations with local communities should be a part of that. So there is a huge ongoing debate on environmental impact assessment, but it was also a huge step forward that such an obligation was recognized. Later on, the court said that obviously both states must continue the monitoring efforts and must do it jointly. That the elemental chlorine-free technology used by Uruguay is in fact compliant with modern environmental standards. And in general, it seemed that when there was some conflicting scientific data, the court decided not to dive deeper into that, not to resolve those differences in opinion, but rather to defer to the principle of caution. So try to play as safe as possible, unless there are some wild and unsubstantiated claims in which they would simply disregard those. And it started a discussion. Not everyone was equally happy with the level of engagement with scientific matters. For example, it was observed that the precautionary principle and the environmental impact assessment should have been explored more in detail, and that the threshold that the court uses for proving significant harm. Significant harm is a term which is used quite often in international law. It's quite problematic when it comes to some scientific uncertainties and those long-term effects that we mentioned. Also, another judge mentioned that there is the need for some more comprehensive and more multidisciplinary studies, which would address the issue more holistically. One important and interesting thing is that they also pointed out that there are some duties owed to the future generations, and this is yet another source of obligations related to environmental protection. Other suggestions include closer cooperation, more transparent scientific exchanges, which we already mentioned earlier, and the usage of some of those guidelines which are already being used by some other disciplines, such as the BAT, Best Available Technology, and the newest scientific methodology. When it comes to some other voices, there was also a voice for yet another one for transparency and completeness, but this was also a separate opinion which mentioned that the scientific submissions of Argentina have supposedly not been awarded enough attention, and especially when it comes to cumulative impacts of the activity, which are very likely to happen given that it was meant to be a long-term investment. So what we see from this case is that even though the court has tried to engage with science more than in a Gabčíkova matter, the way in which it did it, I would say, was a little bit chaotic, and especially because the judges were not sure what level of intervention is the appropriate level from the side of the judge. In general, the more investigation, the less free, the smaller freedom of the parties. And if you look at a system in which the freedom of the parties is something that actively encourages the parties to participate, then you might be quite reluctant to actively ask questions and try to, to see some more problems that the parties are willing to see. So this is obviously a tricky balance to achieve, but this is something that was quite visibly a concern of the adjudicators, the judges here. I will now proceed to the last two examples. They will be fairly short. and they are not as popular, not as widely discussed as the previous two, because they were not about a scientific dilemma, but even though they concerned something different, science still played a role in it. For example, here we had an island. The picture you see is from 2019, if I'm correct. So this is not entirely how it looked in 99 when the case was concluded. But to give you an idea, there's an island on a river, which is a river between Botswana and Namibia. And there was a treaty between the two states which discussed, which did not specify the status of this particular river, but delineated some rules for how the territory is divided between the two states. And to understand whether this island is belongs to Botswana or Namibia, they had to find out which channel of the river was the main one. So what ensued was a lot of scientific measurements of water depth, flow velocity, and volume. It was further complicated by the fact that the flow can shift seasonally, and there were quite a lot of disagreements between the party, which concerned accuracy and representativeness of the normal river conditions in surveys, as well as some other aspects related to the interpretation of those seasonal fluctuation. And the judges finally accepted that the northern channel, which was between the island and Botswana, was deeper and had greater flow than the southern one. So in accordance with the rules of the treaty, the island was confirmed to be the property of Botswana. But nevertheless, as you can see, the depth and the flow of the channel was just a piece of the huge scientific puzzle that could be reconstructed from those various discussions around the channels. And the last example is the newest one, the Silala River, which originates in Bolivia and flows into Chile. And this was quite interesting because Chile claimed that Silala was an international water course and it could use its waters under the principles of international law. But Bolivia said that there were some artificial channels created, so Silala should not be treated entirely as a natural international water course. Fun fact, I was thinking about writing a scientific paper on the Silala case, and when it first appeared before the International Court of Justice as a problem, I tried to find the Silala River on Google Maps, and it was fairly easy to find, but also fairly underwhelming because I found precisely the place where it crosses the border, and it was barely visible. It was a very, very narrow streak of water. As you can see here, it resembles a stream more than a river, but obviously its importance was still huge, and the level of water can vary. It's a very difficult, very, very difficult ecosystem there. So yeah, it's not to underplay the significance of the Silala River, but to tell you that it was a little bit particular. And what happened was that both sides presented plenty of hydrogeological studies, field surveys, and expert reports. What was interesting here was that for the first time that I know of, advanced computational modeling was used to provide some models of how the river could look in various hydrographic conditions, and how the river could look if it was not artificially altered, etc., etc. there were disagreements regarding the accuracy of hydrological modeling software and the level of detail that was involved in this analysis, such as typographic factors, climatic data, and groundwater recharge, which was taken into account to varying extents. But in general, the ICJ reaffirmed that Silala was and is an international water course, so all of those international rules apply to it. In terms of resolving the problem that the parties came to the court with, it was a resolution, but in terms of all of those scientific discussions, this is not something that the court engaged with to a greater extent. And I would like to wrap up by saying what I try to do to help a little bit. I'm trying to write a PhD, hopefully finishing soon, on the role of science in application of international law by international courts and tribunals. But one of the parts that I'm the most excited about is about standards, understood as guidelines, in my case, non-binding guidelines, which would take the form of some very straightforward questions which could be asked by the court to experts of all disciplines, but also they could be used for cross-examination. They could be used by parties to better understand the advice of their own experts. And what I'm trying to do is to make them so understandable to the judges that they could be used even for, I would say, some critical self-assessment. So, for example, if a judge wants to engage with science by reading an expert report or by reading a book on the subject or participating in a scientific conference, they might be able to verify their level of knowledge and their level of understanding by answering those sets of questions. So I would say that even though the discussion on how much science in law and how much law in science and how those two should interact is a very philosophical one, and it's often a very emotional one to some people, it ultimately boils down to some very practical considerations as to the fact that the procedural economy must be preserved, that the parties must know what they engage with, that the courts must feel comfortable in execution of their functions. So I hope that this little part that I will suggest, which builds on the experiences of the US legal system, the experiences of many specialized courts, and the experiences of my predecessors, is going to be a little helpful for judicial practice. Of course, it would be wonderful if somebody reads it one day and says it's useful. So I'm obviously saying it a little bit overly ambitious, that I hope to help the international legal system. But this is the ambition, and we'll see how far we will get. I'm now trying to wrap up my work on the PhD, but if you would like to read more about law and science, especially international law and science, there are some wonderful contributions by Caroline Foster, by Katalin Szuliak, and many others. So please feel encouraged to explore, and I will be happy to hear your questions if you have any. Thank you so much.
Thank you very much, Lena. That was excellent. And yeah, what a range of examples you've covered in the lecture today, and really nice also the link to one of the earlier lectures that you mentioned. And a special thanks, given you're not feeling at your best today. So let's see if we've got some questions. So do raise your hand or type them in the chat. I'll try and find the chat at the moment, and I can see that there is some typing going on, so we do have some questions coming in. Yeah, maybe I'll just start with one. So you talked there at the end about the creation of standards and the set of questions, perhaps, that could be easily understood. Do you think there's also a role in education to move towards more cross-disciplinary degree programs where we might have a kind of basic level of understanding of a number of subjects, although we may all move down to become an expert in one or two areas? Do you think that's part of the answer as well?
Yes, thank you very much. I see a lot of value in creation of such programs. This is also why I was so excited to work on the joint Bachelor in Sustainability in UNA Europa. Obviously, I don't think that Renaissance people or know-it-all experts are going to be the solution. We are not trying to replace specialists. Obviously, narrow disciplinary knowledge is still going to be very, very sought after. But what we also need is people who are able to see the bigger picture and who are able to communicate across those disciplines, to come to this lawyer and this chemist or biologist or geographer who do not really understand each other, or who, for example, operate on similarly sounding terms which mean totally different things, and help them reach some common understanding. Because this is, I think, what happens very often, is that there are many actors in disputes, but also in other areas of life, who want to solve a problem, but approach it from such different perspectives that they cannot really utilize their abilities in an optimal way. So yes, I think that this is a trend that we must address. I also see a growing number of job offers for people who are dealing with interdisciplinary aspects, to the extent that when I started working on the joint Bachelor in Sustainability, I started getting messages on LinkedIn from some headhunters who are trying to pinpoint people with this sort of multidisciplinary knowledge. So yes, I definitely see a lot of value in that, and I hope that some sort of translators for different disciplines could be very useful. In terms of sustainability, I know that sustainability is not the only interdisciplinary field out there, but for example, the creation of the European Union Green Com framework, the framework for green competences, shows that there's a huge drive towards transversal skills and scientific literacy and the ability to understand new information, as opposed to just memorizing stuff and doing things. This is also why I would say this is a little bit a way to future-proof ourselves and our students and everyone else in the context of AI and other assistive tools, because knowledge can always be found in a database to some extent, at least the knowledge as it was understood 200 years ago, as it was understood. But the ability to link those different facts is a more challenging thing, and this is where we will need people still.
Absolutely. Yeah, I totally agree with you. And I can see there's a question now come in the chat. So from Shimini, who was one of our speakers a few weeks ago, what kind of recourse is there in terms of international law in cases where the precautionary principle is not used and a transboundary river is polluted?
Thank you very much for the question, and also for the comment from Claire. This is a very, very tricky question because it touches upon a few things. The biggest thing, the elephant in the room, is in general the effectiveness of international law and the ability to seek some fora for the dispute. The problem is that there's, in cases like that, there is usually no obligatory jurisdiction. So if it happens that the states which are concerned did not subscribe to jurisdiction of the International Court of Justice or any other court, that might be quite difficult to effectively conduct proceedings and then try to somehow enforce any judgment against them. But if we try to avoid this first barrier, and if we say that, okay, there's a court or there's an arbitration body or any other dispute settlement body that is able to take on this question, there's another problem. What is the binding body of law? If there are any treaties which are binding on top of international general international law or not. If there are no treaties, then the first thing I would start with is the no harm principle, which is very straightforward, and it means that the state cannot cause harm to another state. So if there is a transboundary river that is being polluted, the first thing you would have to do is to demonstrate that there is harm or a significant risk of such harm. And then when the precaution, you mentioned that the precautionary principle is not used, you could evidence that, for example, by showing that the environmental impact assessment was not done. And this is why it was very, very important that the court actively pointed out the obligation of the environmental impact assessment, because this is something very tangible. You either have it or you don't. It's very hard to argue that, oh, I didn't know about the possible environmental implications, etc., because, well, you had to look at the conclusions the experts came with. So I would say that you would first must try to find some sort of a court willing to take on that case. Secondly, you should do your best to evidence the harm or try to show why it might be imminent and grave. And then you could use the no harm principle, you could use the precautionary principle as a legal argument, you could use the lack of the environmental impact assessment, and the wide range of treaty-based provisions, because obviously we have also a lot of treaties which deal with environmental protection, depending on which state you are and which state your adversary is, then you would be able to use some of those additional tools as well. And to be honest, this treaty route might be the best one, because sometimes there are some more robust enforcement mechanisms or mechanisms of sanctions that might be applied when you have a treaty as opposed to just general international law. But yeah, you should probably get at least satisfaction. I know it's not much, but it's at least important in the sense that the unlawfulness of the infraction is recognized.
Thank you very much for that answer, and hopefully we can pick up on some of these conversations in a few months' time when many of us will be in South Africa. So are there any more quick questions? Just lots of thanks coming to you for your excellent presentation, Lena. So let me add my thanks, and I wish you a full recovery very soon. And
thank you so much.
Yeah. Okay. So thank you, and that's where we finish today.
Thank you so much. You know where to find me. I have a pretty distinct name, so if you have any questions that will come up later, just ask. Thank you so much.
That's great. Okay. Thank you. Bye-bye, everyone.
Bye.